Welcome to this conversation with an expert witness. My name is Dominic Hopkins. I'm a commercial litigation partner at the law firm HCR. My experience, my area of specialism is in the management of complex technical disputes. And when you have a complex technical dispute, it is very common for you to need the services of an expert witness. In this case, I'm delighted to be able to introduce you to Dr. Meloria Meski today. Meloria is a senior managing director at the consultancy services firm of FTI. Meloria and I worked together on a claim which settled last year in the field of telecommunications. Meloria, welcome.
Thank you for having me.
The case that Meloria and I worked on had particular characteristics which I hope we're going to be able to draw on for the purposes of this conversation. And perhaps you'll be able to derive some perspectives and useful perspectives from our own experiences as we share them today. The particular characteristics of our claim was the dominance, the significance of expert evidence. In fact, there were 6 disciplines of expert evidence, and the particular expertise which Meloria had brought to the claim was the field of statistics, statistical analysis, and econometrics. So, Meloria, do you want to introduce your firm, FTI, and the services that you provide to litigators like me?
FTI Consulting is a multinational enterprise, and among the services we provide expert witness evidence to disputes in the fields of international arbitration and commercial disputes.
For a litigation solicitor in my position, getting the right choice of expert is centrally important. That means investing time in the exercise of selection. It means also ensuring that you've thought through the particular technical issues that the court is going to want to be informed on, and that means ensuring that you are thinking forward all the time. Thinking forward is absolutely vital. Meloria, when you are introduced to a claim by somebody in my position, what is it that you're really hoping to get from that first contact?
So it is fundamental for an expert to understand what are the matters, the principal matters of the case. And this implies having very in-depth conversations at the outset with the solicitor and, if possible, also with counsel. That is of fundamental importance for 2 reasons. The first reason is that it allows the expert to frame the questions in the appropriate way. And the second is because it introduces an element of efficiency in the costs of the dispute.
Meloria, that's something which I really share with you, that idea of getting the briefing right at the beginning. And in this particular case that we were involved in, one of the key things was the amount and quantity of information, data that was involved. Was that a big challenge?
Yes, it was a challenge, not so much in terms of the amount of data, because we have now, and especially in my firm, we have sufficient computing resources to deal with this data. But when the data is of a quality that is not tip-top, can I say, and also does not come all together, that can create problems in the work that needs to be done.
And in this case, what was characteristic of it was that the data that we were receiving from the claimant, we were acting for the defendant, was coming in fits and starts.
Yes.
And the data quality was also quite important.
Yes. First of all, the data was related to several millions of records measured on a weekly basis for a period of years. So it was a large amount of data. And it did not come all at once because of issues with the provision of this data. There were several instances in which the data was called back and then resubmitted because because the other side had found errors, and therefore this had to be done. And qualitatively, and this was an unfortunate situation of the case, nobody's fault, but qualitatively the data did not measure the variables that we needed for our analysis.
In this case, we had hundreds of millions of lines of data which needed analysis. You don't do it on your own, do you?
No, it's impossible. You need a team, and not only a team, but you need computer resources. So I am fortunate that FTI has a data analytics team, and FTI also has the use of very large servers in which the data can sit. The team that you need to do this type of analysis is multifaceted, because you need people who are able to analyze data, so who have the computing and the artificial intelligence skills to analyze such a data set. And then you need people who are capable of modeling this data, so people with statistical skills as well.
This case was also interesting because of the interdependencies of the expert. The case was of interest because of the number of disciplines, but also the type of disciplines that were involved. We had three different engineering disciplines. We had a material science expert, as well as a statistical expert in malaria, and also an expert in the calculation of loss. In this case, there were interdependencies between the different expert disciplines. So Malaria was speaking to questions of both liability and quantum. But of course, with those disciplines, that number of experts involved, that presents some sort of complexities of how you manage the process. Malaria, what was your experience of dealing with the different experts on this particular case?
So normally, generally speaking, when you work on a case that requires statistical expertise, the expert needs to draw information from technical experts, because the purpose of having a statistical analysis is to make sure that the causality between the act and the output is measured correctly, and therefore that any confounding factors be cleaned out of the data. And in order to do that, one needs to understand what these confounding factors are, and this is the type of input that comes from technical experts. So it is of fundamental importance to have that type of input in a timely manner. At the same time, once we know what component of the loss can be attributed to what you're trying to measure, to the act, then the statistical expert needs to supply the information to the damages expert. It is fundamentally important that the matter be managed by the solicitors working on the case, the instructing solicitors, in such a way that there is a seamless cooperation among the experts.
And that's a really interesting challenge. And I think for the litigation solicitor, of course, it's a bit like a chessboard, actually moving pieces on the chessboard to ensure that ultimately you have an efficient system going to get the outcome for the client, ultimately. Ensuring that there is collaboration between your own experts and that they're talking at the right time on the right subjects to each other. Getting that right is centrally important because of the potential cost implications of getting it wrong. Malora is an expert in efficiencies. This is one of those experiences that we had with this particular case, was to ensure that the experts were working with the solicitor's team to ensure that there was efficient cost management and that we were not being excessive in simply because of the way in which we had decided to communicate with the various experts. An expert witness in litigation and arbitration is required to be independent. Of course, clients might have a very different view of what they want from their expert. They would like perhaps a more partisan view, but that's not the expert's role. That's, I'm afraid, built into the role of the expert witness. It is also a characteristic of these cases that the experts on both sides collaborate. Their expectation is that they talk together, so that it's not just the experts for the client, it's the experts for the other side as well. In that regard, this was quite an interesting case for a collaboration where there were 6 disciplines of expert evidence on each side. Malora, what was your experience of working with experts on the other side in this claim?
For my particular area of expertise, I only collaborated with the statistical expert on the other side. Several of the questions which were asked by the court were asked not only to the statistical experts, but also to the engineering experts. And so when I met with the opposing expert, we had to go through the positions also of the experts for the other disciplines in order to slot our response into that framework. It was a very complex exercise, and I think it was particularly complex for you, Dominic, because the other disciplines, the other 4 experts, I think, other than the damages expert, they all had to meet together and write fill out a single matrix of positions, and that must have been dreadful.
Well, it was very challenging, but what was quite an interesting dynamic of this particular case was that even within a discipline that the court had identified as a necessary discipline for technical evidence, the experts on each side had different expertise within those disciplines. And therefore, actually, the number of experts that you had, expert stories that were being told through the evidence, was much more diverse than perhaps those 6 expert disciplines might have suggested. Now, that creates a really challenging task when you are getting experts to try and produce a joint statement, which they're expected to do, because perhaps where there are overlapping disciplines as well, which there were in this case, that one expert might want to speak to another expert's opinions. It can be quite complicated, very challenging. One of the important things for a litigation solicitor to do is to think very carefully about how they brief and communicate with their own expert to ensure that they are clear with the expert about what issues they need to speak to, and not to go off piste, go on off story. That can be quite a challenge sometimes, because of course we all like expressing opinions. Experts are being retained to express an opinion. It's important to keep confined to the issues that the court is expecting you to express a view and provide assistance to the court on. That's really centrally important. So, Meloria, we've talked about the importance of collaboration. We've talked about the importance of ensuring that the expert is able to be independent in their opinion. Do you want to make some observations on that aspect in particular, in terms of your relationship with the solicitor, the instructing solicitor, and ensuring that you're able to give an independent opinion to the court?
It may happen during the course of a case that we as experts are subject to pressure from the client to reach certain conclusions, to find certain numbers. And this is something that it's not, it's very untoward, but it's very natural, because the client is worried about their position. And it is of fundamental importance to retain independence, that the expert does not fall victim of making decisions that goes against their belief. And in this respect, in essentially holding back from pressure, it's very important to have the support of the solicitor. The instructing solicitor needs to understand when the moment is ripe for having a discussion with a client, because an expert cannot bend to pressure. That's not possible.
That's a really important point, Melora. I entirely agree with you there. It is vitally important that the expert is able to express themselves independently and to ensure that they're not pressurized by the solicitor who is instructing them to express an opinion that might be that which the client expects and requires. If you seek to control an expert, the expert might well be unhelpful in court, in cross-examination. And that brings me to another vitally important aspect of selecting an expert, and that is to choose an expert who is not somebody who is only capable of producing an erudite technical written report, but somebody who is able to communicate clearly orally in a court. Meloria has had considerable experience in appearing before a range of tribunals, and that was influential in why we asked Meloria to provide evidence for our client in this particular case. Meloria, that's really important, isn't it? Being able to communicate clearly to the judge.
Especially when your subject is very technical. I have to say, for me personally, I have an advantage in the sense that I have taught undergraduates for a very long time. And therefore, in order to keep them engaged and in order to make them understand the subject matter, you need to bring it down to something that they can grasp, essentially. And so the use of examples is extremely important, in my opinion. And of course, when you deal with a court, you are dealing with a judge who is a very highly intelligent person. But as you, as an expert, do not understand the law, you cannot expect the judge to understand your statistics or any other technical matter. In order to be able to be effective, you have to be able to communicate your subject matter in a simple and intuitive way. This can be possible in some cases. In other cases, when the matter is not intuitive, you can always use examples. I find that very, very helpful.
Managing the client's expectations is vitally important also. That's particularly so with expert evidence because it's costly. It costs a considerable amount because it's based upon time spent. And as the story of a case unfolds, it can be that the requirements for expert evidence change, they might extend, they may become much greater than originally anticipated. And that has a significant cost implication for the client and ultimately, potentially, for the outcome of the claim. Meloria, in terms of managing costs, what would you say are the priorities?
The most important thing when you manage costs is to be able to forecast what it is that needs to be done. Once you know what needs to be done in terms of tasks, then for an expert, it is to actually assign these tasks to the relevant people within the team. Because if somebody who is not the best person to undertake that task is put on the team, then you end up having to train them, to brief them, and to spend much more time and therefore much more money than necessary. There are factors that drive costs, and these factors need to be made upfront clear to the client and to the solicitor. So, for example, if data comes in bits and drabs, if the data is not qualitatively good, if much analysis needs to be done, much more than you expected, that will drive the costs up, obviously. So one of the things that I always find useful is to send weekly wrap-ups of what has been done during the week, how the costs have been incurred, and what needs to be done in the weeks to come, so that everybody is always appraised of the financial situation of the case at any given time.
That communication of what is required, what the next steps are, and what also has been done, and what costs attached to it, has been really useful. And I think the way in which FTI managed the costs reporting and the task reporting, it really was very helpful indeed. So great thanks to you, Meloria, and your team for the way in which you did that reporting. Very helpful. Meloria, we've covered quite a lot of ground today in this conversation. I think it would be useful to have some takeaways.
So for me, the first is, as an expert, to be actually fully briefed from the very beginning, to retain a very collaborative relationship with the instructing solicitor, and so to have regular meetings, to have regular exchanges of ideas, to listen to your solicitor when they are telling you that you are using, for example, obscure language or to clarify matters. The relationship with a solicitor is very important. And I have to say that in those 3 years, I really, truly enjoyed working with you.
Likewise, Meloria, and I have to say that I would entirely agree with you that the centrally important takeaway from my perspective is that relationship that you build up with the expert, that relationship of trust, that ability to have an open conversation with the expert and be frank, but also understand the independence that the expert is expected to demonstrate, and not to trespass over that line that would seek to essentially control what your expert witness is required to do. So I think from that perspective, I think we had a really positive relationship, and I think the client ultimately benefited greatly from that investment in the relationship that we had throughout the case. So I hope you've found this conversation interesting and helpful. I'd like to say a big thank you to Meloria for the time that she's given us today in what is a very busy time, I know, with lots of cases.
Thank you for having me. It was a pleasure.